Hello, students. This is the video lecture for Chapter 8, which is about covering the courts and different issues associated with covering legal proceedings. And bonus question, it's not worth any points, but bonus question, you can see this black and white still image that I put on the first slide. What film is this image from? Okay, question at the end of the lecture, what film is this image from? First up, we have the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. Now, this creates a situation. We have a tension between the First Amendment, number one, and the Sixth Amendment. First Amendment, as you all know, is about the freedom of the press and freedoms that journalists and people who work in the media enjoy in the United States. Well, if they're allowed to cover legal proceedings, but then people also have a right to a public trial by an impartial jury, that creates some tension. How can you be covered by an impartial jury if you've already been convicted in the court of public opinion, as it were? Like if there's massive press coverage about a trial and you're already depicted as the villain or the perpetrator of some horrible crime, that could theoretically taint potential jurors who haven't even been selected yet. So how can you have a fair trial and then also allow freedom of the press? So we will explore some of those tensions in this lecture. I just mentioned the conflict, the essence of the conflict. And I also want to say, I'm looking at some notes here from the textbook. Media and media coverage can affect people's attitudes towards policing and towards the criminal justice system in general. For example, people of color are often overrepresented in stories about crime, overrepresented. However, I remember learning many years ago when I was an undergraduate myself that white collar crime, financial crimes, things like embezzlement, tax evasion, things like that, white collar crime costs the United States government far, far more than sort of lower petty crimes or maybe even violent street crimes. But we get more press coverage of the street crimes, things like burglary and robbery and things like that, than of white collar crime. So this kind of constant press coverage can affect people's opinion and it can affect your judgment. And then, as I mentioned previously, when you're tried in the media, it can affect potential jurors. So that is definitely something that the courts and journalists should be aware of. One bit of advice, one important bit of advice here. I got this from some of my colleagues, some other journalism professors. Do not talk to jurors during a trial. Okay, say you are a young journalist, this is your first job out of college, or maybe you are even covering a criminal proceeding for a class, like a class in JMS. Sometimes jurors are sequestered. That means they're put in a hotel room and kept kind of secluded from the outside world so that other opinions and press coverage does not affect them. But they're not always sequestered. Okay, so maybe you're covering a trial, you see someone who's a juror, and then you're going to lunch or getting coffee next to the courthouse. You see the person, you want to walk up and talk to them. Do not talk to jurors. Okay, worst case scenario, you could cause a mistrial by interfering with the judicial proceeding. So even if you have the opportunity to talk to a juror, look, the person's right there. I need a quote from my class project. Don't talk to them. Okay, do not talk to jurors. I'm going to talk about a very, very famous court case that had a massive amount of press coverage from the mid-90s. But before I talk about that, I want to talk about this much older case. This goes all the way back to the 1930s. Charles Lindbergh, first person to fly solo across the Atlantic. He was just a massive, massive celebrity and heralded as a hero when he did this. His child, I think it was a daughter, was kidnapped. Okay, his daughter was kidnapped. They apprehend this man, Bruno Hauptmann. He's put on trial for the kidnapping. And I wasn't alive back then, but I do remember reading about this and learning about this when I was a very young child. Like this, there had never been in the United States any kind of court trial with this level of coverage before. And we had forms of mass media. We had radio, we had film, and obviously we had newspaper coverage. Here is an ad from a Chicago newspaper from 1935. And if you can see here on the upper left, they were showing, I presume this is newsreels, they're showing newsreels of the trial and advertising that, look, next to other sort of films that you could see. Like, this was a public spectacle. This was a public spectacle. And here we have another headline from around the same time, 1935, Bruno Hauptmann is found guilty of murder. Okay, spoiler alert, the child was not found. Okay, the thing that I wanted to talk about, a more or somewhat more recent media spectacle about the courts, was the trial of O.J. Simpson in early 90s. I think it was 1994. I had already graduated college at that point. I remember when this was going on. O.J. Simpson had been a rather successful football player, and then after that, he transitioned to becoming a Hollywood actor. He wasn't in great movies, you know, he wasn't in like the most stellar films, but he was a pretty well-known celebrity. He also did a series of car commercials for some sort of rental car company. Anyway, he's put on trial for the murder of his ex-wife, and then also this young man, Ron Goldman. Horrible murder. Both bodies found, you know, brutally murdered. O.J. Simpson was the most famous person at that point who had ever been put on trial for murder. Okay, O.J. Simpson was the most famous murder defendant. And the press coverage of this was like nothing that people had seen before. Okay, if you thought Lindbergh was big, now we have television and cable news in the mix. And many people believe, myself included, that the presence of the cameras tainted and I wouldn't say corrupted necessarily, but definitely influenced the behavior. The way the lawyers for the defense and the prosecution, the way they were behaving and acting, and the things that were saying were being staged for the audience at home, not necessarily for what was true or what was factual. And O.J. Simpson was ultimately found not guilty. He was later found guilty in a civil trial, but the original trial, he was found not guilty. And many people believe that the press coverage did affect the outcome of that trial. Okay, continuing this theme, and this is the last famous murder trial I'm going to talk about, Shepard v. Maxwell. This was a case, the crime actually happened in the 1950s, but the Supreme Court did not hear the case until the 1960s. Sam Shepard is a doctor. He claims that he returns home and claims that someone had broken into his house and killed his wife. He was put on trial and originally found guilty of the murder. He claims that there was someone else involved. He wasn't the one. This was, you know, yet another example of a very famous media spectacle involving a murder trial. The case was so famous, it inspired the TV show The Fugitive, which then later inspired the film The Fugitive, which stars Harrison Ford. Actually, a pretty good film if you like movies. That's a pretty good film, The Fugitive. Anyway, when the Supreme Court finally hears the case, they overturn the conviction. Okay, they free Sam Shepard, claiming that the massive amount of pre-trial publicity made it impossible for this man to get a fair trial. That there was simply too much press coverage, and that it wasn't fair. So following this, I'm looking at my notes again, following Shepard v. Maxwell, a number of measures have been put into effect to try and preserve the integrity of a jury trial. This includes delaying a trial. A judge may say, hey, let's wait until people calm down. Now, the Sixth Amendment says you have the right to a speedy trial, but a judge may say, you know what, let's wait 6 months until people calm down. Change location, like, you know, people are too upset in this town, let's move it to a different town. Sequestering of the jury, that's, as I mentioned, when you put the jury into, you know, private places to stay. There could be a gag order on participants, not allowing them to talk about it. Don't reveal certain information to the press. Potential witnesses can be put under protection to protect them from outside influences. There can be special instructions to the jury. There can also be limits on the press and what the press can do and how they can cover the trial. And I think the worst case scenario is a complete retrial when the judge says, you know, this proceeding has been so messed up, to put it politely, we have to retry the whole case. So there are a number of things that judges can do to try and preserve the integrity of a trial. Okay, when it comes to cameras in the courtroom, the situation is very complex. Here's from the notes. I think this is straight from the textbook. Cameras are allowed in some courtrooms some of the time in all 50 states. Okay, some courtrooms some of the time. They are never allowed in the US Supreme Court. The US Supreme Court has never allowed there to be cameras in the courtroom. Some people don't think that's correct. Some people do think that's correct. In federal courts, circuit courts sometimes have cameras. It's up to the discretion of the judge. Some states are more permissive than others. Florida is rather permissive. So if you do find yourself functioning, working as a journalist, find out what the laws are in your particular state, but just know that there's no cameras in the Supreme Court. Here is a case from 2021, the murder trial for Kyle Rittenhouse. If you don't remember, this was during all the protests over Black Lives Matter that happened in the summer, one summer, I think it was summer of 2020. Kyle Rittenhouse, young man, has a weapon. He probably shouldn't have had the weapon in the first place, crosses a state line, deliberately goes to a place where he knows a protest is going on. There's an engagement with some protesters. He ends up killing, I don't remember how many people he killed, 2 or 3 people. When he was put on trial, the judge did allow cameras, and there was this very, very famous scene, if you don't remember it, where Kyle Rittenhouse goes on the stand and cries because he's so upset. Some people said he was faking the tears, right? Some people said that he was just acting. Other people thought it was legitimate show of concern. And there was just so much public discussion about this and so many images and videos circulating that the judge later said, had I known it was going to be like this, I never would have allowed the cameras in there. I never would have allowed the cameras in there. And in this case, Kyle Rittenhouse was ultimately found not guilty. I think the jury found that he was acting in self-defense. But this was another instance where cameras were allowed, and then people later debated, was that a smart thing to do or not? Now, when it comes to social media is a constantly evolving situation, right? We have new and new technologies, new platforms all the time. Judges are trying to figure out how much to allow. Much like cameras in the courtroom, the argument for allowing these things is that it allows full transparency and that the public has the right to know what's going on. The downside is that maybe sensitive information can get out and too much information can get out there. So this is an ongoing and evolving situation. Okay, now we have Brandsburg v. Hayes. If you can only remember one court case from this video lecture, this would be the one. In Brandsburg v. Hayes, the Supreme Court ruled that freedom of the press did not create a constitutional privilege protecting reporters from having to testify in grand jury proceedings about the identity of a news source or information received in confidence. Now, this is very specific to a grand jury proceeding and very specific to the identity of an otherwise anonymous source, that courts can rule that reporters have to reveal the identity of a source. Okay. Now, following Brandsburg, a number of states did enact something called shield laws. 17 states already had something like a shield law. Now a majority of the states do. There is no federal shield law. Okay, there's no shield law at the federal level, but some version of this does exist in most states. Now, what this means is that a reporter has a privilege in some instances to keep the identity of an anonymous news source anonymous. In some instances, there may be a case where someone comes forward to reveal some very damaging, very, very important information, but doesn't want their identity revealed. So they say, I will only reveal this and anonymously. So a shield law is something that allows the journalist to maintain that type of anonymity and maintain the privilege. And again, like with everything else, these are all subject to debate, and it varies state to state, and it varies by the specific wording of the state's shield law. There is some ambiguity about who is covered by a shield law. There's great difficulty in defining journalists. Now, the courts have tended to prefer the term journalist, as you know, we don't have licensed journalists, for better or for worse. We do not have licensed journalists in the United States. But if you work for a media outlet that's very reputable, maybe very large, does things like fact checking and engages in fair and established journalistic practices, maybe you are a member of the Society of Professional Journalists, the courts will tend to prefer that. Now, if you're a blogger, you just throw up stuff on social media, you know, people claim they're journalists. I'm an amateur journalist. That's a much more gray area. You know, someone who expresses opinions online doesn't necessarily meet the criteria that the other journalists might meet that I just defined. But again, it's, you know, a gray area because we do not license journalists in the United States. Hackers can be a protected source depending upon the kind of information they're reporting. And the reporter's privilege can also be waived. If someone originally says, I'm an anonymous source, and then maybe they later change their mind and come forward of their own free will, then the reporter's claim to privilege kind of goes away. So there is some ambiguity with the shield laws. Now, in many areas of the law, like when we talk about obscenity or other things like this, juveniles, people underage, are considered kind of a special demographic, and they may need special concerns. Courts generally limit access to juvenile proceedings. They're not automatically considered open. And I think there's some good reasons for that. You know, if someone's young and commits a crime, you don't want to, like, you know, tarnish them for the rest of their life. Maybe they stole a car, you know, they have plenty of time to make amends and become a reputable, good, upstanding citizen of the community. So that there are different rules when it comes to covering juveniles. And again, it varies by state to state. When it comes to sexual assault victims, all states, including the District of Columbia, have a rape shield law, which means that if a person is the victim of some type of sexual crime, sexual assault, their identity should be kept secret. You don't want to necessarily make that public. That could make the situation worse. It could sort of exacerbate injuries, as it were. And in most states, except Mississippi, okay, Mississippi isn't alone here. In most states, there are rules about questioning a witness's past sexual activity. Just because you engaged in certain type of behavior in the past shouldn't tarnish your reputation or make you any less reliable or less reputable. But I think you could see how maybe an unscrupulous or sort of unethical lawyer might question that. Like, you know, hey, you dress like this, you did this in the past, therefore you were clearly asking for this activity which happened to you. So all the states except Mississippi don't allow that line of questioning. And as I mentioned, the victim's identity is generally shielded. Now, other types of court cases can also be closed to press coverage or greatly limited press coverage. If there's some danger to national security about the information getting out, anything that's involving the Foreign Intelligence Surveillance Act is generally considered to be closed. And there's a great concern here about the risk of divulging state secrets. I heard a great podcast not too long ago about the legal issues involved with people on Guantanamo Bay, people who had been accused of committing terrorist act. In some cases, they had never been accused at all. They were just locked up. And, you know, some of these people were, you know, locked up in Guantanamo Bay for years. I think some of them might even still be locked up. And then the press can't even figure out, you know, what are they charged with, what's going on. And the government claims, maybe they're exaggerating, but the government does claim that there is some issue of national security here. And in conclusion, To Kill a Mockingbird, the film that is depicted on the opening slide of this lecture was To Kill a Mockingbird. That's it for the lecture.